The content of the following program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we practice intellectual property law, including patents, trademarks, and copyrights. You can check us out online and view all archived episodes of this show on our website at oltmanpatent.com. That's OLTMANPATENT.com. A very special guest in studio this evening. His name is Adam Goldberg. He's a partner at the law firm Krause & Goldberg in Weston. Adam practices in the area of estate planning and probate. He's also a professor of law at Nova Southeastern University in Davie, where he teaches estate planning, probate, exempt organizations, and will drafting. This evening we're going to be talking about estate planning and probate, and I'd like to welcome Adam to the show. Adam, thank you so much for joining us.
Thanks for inviting me, Jeff. I'm happy to be here and share some of my knowledge and wisdom with your audience.
So let's just begin by defining what is estate planning.
Okay, estate planning is basically defined in two different aspects. It's paperwork, decisions, procedures that you put in place during your lifetime that will have an effect either when you become incapacitated or when you pass away. And there's a number of different types of documents, both from a financial perspective and from a health perspective, that could be effectuated by the documents and the procedures that you prepare.
So one of the important things that we have to consider for what happens after we pass is how are we going to dispose of our property? And that involves having a conversation, often with your loved ones, that a lot of people don't want to have.
Well, if you look at the statistics, and I think it's Court TV, which is now True TV, says that only 30% of the general public in the United States has a will, which is just the minimum type of documents here. And among lawyers, it's not that much better. It's only about 66%, so only 2 out of every 3 lawyers. It always reminds me of the cobbler's children have no shoes. So when the lawyers die without a will or without something taken care of. But sometimes people are afraid to talk about it. They're embarrassed. But a lot of it is they just don't want to. It's, let me stick my head in the sand and I'm not going to die.
It's amazing that the inevitable often escapes us, but a lot of it's just not wanting to even consider those issues. And from the perspective of children and spouses, that's something that's uncomfortable to even broach that subject.
It's interesting, with today's nuclear family, you have his kids, her kids, their kids, adopted kids, stepkids. Then you have families where they're still taking care of their parents, or maybe they have a special needs brother or cousin or somebody that they're taking care of. So there's so many different avenues. And with I'm not a family law attorney, but with the high divorce rates, we see a lot of the his kids, her kids, and their kids. And again, sometimes it's just that somebody's going to be unhappy with the decisions, and nobody likes putting themselves into situations where somebody's going to be upset or unhappy.
And, we're talking about disposition of property, but perhaps even more important is what one's wishes are in the event that they're eventually find themselves in a terminally ill vegetative state. And that's something that even though people might live with each other, spouses, or even their children, oftentimes that conversation never takes place until it's too late.
We had the famous case a number of years ago. Governor Jeb Bush was involved with the one woman where her husband wanted to pull the plug.
Terry Schiavo,
of course. And the parents didn't. And they pulled the plug so many times. And finally, after a lot of court time, the husband won because Terry didn't have any documents that said what she wanted. She could have done a very simple living will that just would have let us know what she wanted, would have saved that whole process of time. But again, it's thinking about something negative and not everybody's willing to consider or make the decision, even though every time you check into the hospital, they always do ask, do you have a living will?
Exactly, and that's something that unless you have that, or even a do not resuscitate order,
It's a little different.
that's a little bit different. But if you don't have a living will, then your wishes, you might be put on life support for a very long time, and that might not be consistent with your wishes.
Exactly. Or somebody else is going to have to make that decision eventually. And if there is nobody out there, it could eventually be a guardian through a court system. So some judge and some appointed guardian that you've never met could be making that decision for you.
A faceless stranger that's ultimately
There you
going
go.
to determine how much pain that you endure before you pass. So this is a very important thing to have this discussion. And it's also important in many instances to retain counsel if necessary.
It is definitely a good thing to have somebody to help you through the process. Certainly, there you could go to Office Depot and buy form packages. You can do things online, but generally, it is much better to have a professional come in and work with you and work through the process. Yes, it perhaps might be more expensive than some of the other alternatives, but better to spend a little money now than do a lot of suffering and spend a lot of money on the back end. We were talking, just as an example, Anna Nicole Smith, who died in Broward County, and all the expenses and lawyer's fees and everything that went into the fact that she never updated her documents.
Right, that happened in 2006, and then there was the whole paternity issue
for the
that
youngest
happened after
child.
that. Right, exactly. And so you even see this with celebrities that have many millions of dollars with which to engage in estate planning. I mean, we understand, and also for healthcare planning too, which is sort of part of the same thing. But even they often don't have these discussions.
Yeah, I mean, just in the most recent time, we have Whitney Houston's daughter, who was just pronounced dead. And so now the question will be, is the money that was in trust for her from her mother, Whitney, where will that money go? The general public may never find out that answer, but we see these things all the time. Robin Williams is another case, of course, of one where we see that family's actually fighting in California right now.
Right. So, and we're going to get back to that in a little bit, but, one of the things that misconceptions that a lot of people have is that unless you're very wealthy or you're a millionaire, those are the only people that need wills. Those are the only people that would need to actually decide how their assets are going to be distributed. But that's not always the case.
I'm smiling because I hear that all the time. And, these documents do a lot of things, and some things are very simple. Sometimes it just tells us whether or not you want to be cremated or buried. Or maybe you have a family burial plot in New York, and that's where you want your final resting place to be. So those are some very simple things. Then, of course, we get to the complicated things. But I tell my law students, just if you own a car, you have an asset that we need to deal with when you pass away. So we need to decide a few things. It's not only who's going to get the assets, but how are we going to deal with any creditors, and probably almost most importantly, is who's going to be in charge. But the one that is really the kicker is if you have children under the age of 18, then you need to have a document, be it a will or a pre-need guardian form, that says who would you want to have custodial care of those children if anything happens to you prior to those child or children turning age 18.
Well, just to give another example of something that could happen, I have a friend of mine that represents insurance companies as an attorney, and he was telling me recently about a case that he came across where there was a young mother that was making minimum wage, and she had, I think, a couple of her children in the car. I think she had two children. They were in the car with her. They were all killed in a fatal car accident. Now you have a wrongful death action with an insurance policy limit of $5 million or something. So now you have an estate that's worth $5 million for somebody that in their lifetime really was living paycheck to paycheck. And now there's no way really to distribute those funds. It's going to take a long time now because that money was not, or rather there was no document that disposed of what assets she might have.
In that case, it would go through what's called intestacy, which in Florida means that the state of Florida dictates who would inherit those funds. And if you can imagine a family tree, the general rule of thumb is we look down, then up, then sideways. Down would be we look for children. So when you have that fact pattern where everybody died at the family reunion except for the 1-year-old who was too young to go, they might be inheriting hundreds of millions of dollars between all those people if nobody had any documentation otherwise. Then if there's no children, we look up for parents or grandparents, and then if there's none there, then we start looking sideways for brothers, sisters, cousins, uncles, aunts. There's actually a giant family tree that we could show that shows all the different layers, and that's when you get to, my third cousin 3 times removed. That might be the end person to actually inherit if you have a very small family.
And what you're referring to intestacy, that means the term intestate means you die without a will. If you die testate, that means you die with a will. But like you just said, that's a situation where the government assumes what your wishes would have been.
That is correct. The state of Florida fills in the blanks for you.
And that means that if you have any special wishes about how your property is distributed, then that's something that you're going to have to make a will or a trust for.
It's true, and it's absolutely even more important if, heaven forbid, you have a special needs beneficiary. Perhaps you have a child who is never going to be able to work and maybe on government assistance. You have to leave that child an inheritance in a very specific way, generally called a special needs trust. So all the more reason why sometimes it's absolutely imperative that you come in, because it's possible somebody could inherit and that could be to their detriment.
What you're referring to with the special needs trust often comes up with catastrophic personal injury cases where, let's say that there's a child at a very young age that is injured in an accident or a defective product or a defective drug, let's say, that they're taking, or they suffer brain injury, and like you said, they'll never be able to work. In that case, they're going to need government benefits for the rest of their life, usually in the form of Medicaid.
Absolutely.
And in a situation like that, they might receive a lump sum settlement or a verdict, a judgment, let's say, might be part of a class action or an individual lawsuit that's brought, and those funds would make the child ineligible for Medicaid benefits until all of those benefits are spent down, and they would be spent down eventually, but you want to preserve those for the care of the child to supplement the medical benefits as opposed to having to spend down all of that money.
Absolutely. And sometimes we have special assets. You deal with patents and trademarks. Those are difficult assets in terms of distribution at death because there's some there's some estate tax consequences that go with whether or not somebody can inherit an asset like that. Or sometimes you have a business and it may be that one child's involved in the business and one isn't. Well, do we leave the business 50-50 to the child that's participating and the child that's not? Or do we try and find other assets to give the child that doesn't participate? So not only special beneficiaries, but special assets sometimes.
And in that the business context you're talking about, you would say, well, common sense, you would probably leave more to the child that's participating compared to, let's say, a child that has had no contact with the parent that owns the business in a situation like that. But the government doesn't, when the government writes the intestacy laws, they don't necessarily take that into account.
No, not at all. You might be leaving stuff to a child that you haven't spoken to. The worst ones, of course, are people that are legally separated, if you can call it that, but never divorced. So they might not have talked to each other in 20 years, but because they technically were still married, if the person died without any documentation, they may be leaving a very large bequest to a, in their mind, former spouse, but under the law, their current spouse.
Now, that brings us to the issue of what's called elective share, which has been adopted in every state to some extent, certainly in Florida. In Florida, it's 1/3 of your estate.
30%.
Or rather, it's 30% of your estate upon death must go to your surviving spouse. So you cannot disinherit your wife or husband when you die. They're going to get 30%.
That is correct. And remember now, for all people out there, when we have male spouse or female, that applies to them as well now, if they've been married in any state at this point in time. So you must leave your spouse 30% of your estate unless you have a prenuptial agreement, that would be an agreement before the marriage, or a post-nuptial agreement, which would be an agreement after marriage. What I would suggest is all 49 out of the 50 states have a very strong elective share law. Georgia is the only state in the union that has a very weak one. So if you're too afraid to ask for a prenup or a postnup, you better move to Georgia. It's the only state you really can almost disinherit your spouse.
Now that brings up another issue about people that may have made their will or had their will drafted in one state while they were living there, and then they moved to a different state. That's often the case in Florida. You got people that were snowbirds that come down to Florida and stay here permanently. Does Florida recognize wills that are drafted in other states in
Under-
all instances?
Yeah, under the Full Faith and Credit Act of the United States Constitution, Florida will recognize the will if it was recognized in the state that it came from. So if, for example, in Pennsylvania, they'd allowed a will with only one witness, Florida would allow that. Now, there is one exception to the rule. Louisiana, as you may know from some of your other speakers, has the Napoleonic Code, which is very different than most other states. That allows for an oral will. Under no circumstances will Florida ever allow an oral will. So that's really the one exception. But usually we want to review those documents. If they came from any of the community property states, those rules are very different. So when IBM moved a bunch of their employees from California to Boca Raton, we had a lot of estate plan. We were retained by a lot of those people to review their estate plan to just make sure that, it would be what they wanted, considering we were playing with a different set of local laws. So it is very important to review them, and a very long answer to your question, but yes, almost all of the time, if it's a written document, Florida will accept it if it was acceptable in the state that it was written in.
Now, does that apply to holographic wills? That is, those are wills that are not witnessed, that are written
For the
and
most part,
signed by
Florida
testator.
considers those to be an oral will. A holographic will would only be acceptable for the disposition of tangible personal property, which we tend to call a separate writing here in Florida.
Okay, so that's something that you might. Well, most people probably don't have holographic wills. No. In any case, if you do, then you probably should draft a properly executed will. But this is really brings up that if you have a will, a trust, or healthcare documents that were drafted in another state, and you move to a different state, it's probably worth the time to at least have an attorney from the new state that you moved to at least review those documents.
Absolutely. And I actually have 4 reasons for doing so on top of that. Even if the laws were substantially similar, your preferences may have changed, your finances may have changed, your family may have changed, or the federal law may have changed, or the local procedures may be different. The federal estate tax this year, the exemption is $5,430,000. That changes every single year, and it's important that if you're near that number, your documents, reflect that you've considered that.
Now, I'd like to talk a little bit about the distinction between a will and a trust and when you might use one or another, because a will has to go through a court process called probate, and a trust can be used to avoid that under some circumstances.
Yeah, there's no magic. I wish I could give you a magic formula or say if you're worth X dollars, you should have a trust or you should have a will. The way I describe it to people as a very basic form is I compare it to cars. If you have a Honda and a Cadillac, they can both take you to the mall and back. But the Cadillac does it with a lot more bells and whistles. You might have an air-conditioned chair. You might have more radio stations. You might have better sound system. So the will is the minimum document. It is the document that at very minimum tells us who gets your assets, who's in charge, what do you do with my body, and how do we pay the creditors. Hopefully signed in front of 2 witnesses and a notary. The trust can be so much more. The trust, because it avoids the court procedure, is a much longer and to some extent a more complicated document. So another way of looking at it simply is a will is a document that has no power until you die and the court accepts it. A trust is a document that has power now, and because you've set up all the rules and regulations, there's no need for a court process. Now, to answer your question, in terms of whether or not you need a will or a trust, you should have at least one of them. And when you have a trust, you do have a will. I have clients that are worth millions of dollars that are very happy with a simple will, and I have clients that are worth very little, but they've set up a trust because maybe they have a special needs beneficiary, or they have a child that they're disinheriting and they want to make sure that the document is more difficult to challenge. So there is no magic number. They both do the same thing, they just do it in different ways.
Now, we were talking earlier about the Robin Williams case. In that case, that involved something that was pretty complicated called a life estate, and then that subsequently led to some of the family members fighting with each other over the tangible personal property.
So, for the benefit of your listeners, let me give the quick family tree. Robin Williams was married 3 times. He had 1 child with his first wife, 2 children with his second wife, and no children with his third wife, to whom he was married when he passed away. The interesting thing, he had trusts. So normally that would not be something that would have gone public. The problem in his estate and what we're reading about is they're not really fighting about the money. They're fighting a lot about the tangible personal property. The document didn't go far enough. Now, maybe Robin didn't think that his children from the previous marriages would fight with his current wife, but they're fighting about bicycles, and he had a very well-known art and watch collection. We don't know what it's made up of, but it could be, if there's a lot of Rolexes or other types of watches, it could be significant value. And so the question is, who gets all of the tangible personal property? And they're fighting about that. The only financial part they're fighting about is what you mentioned is the life estate. Robin Williams owned a very nice home in Marin County, which is near San Francisco, and he left his wife, his third wife, the right to live in that property for her lifetime, which means it's hers for her life. She can walk away from it, she can give up the life estate, or when she dies, it reverts back to the 3 children. But what he also put in the trust, and again, we're speculating a little bit here because the official copy of the trust we've never seen, but from what we're reading, we're led to believe that the trust says that I leave her a life estate along with the expenses necessary to maintain the home. That's not very specific. So they're fighting about what does it mean to maintain the home? Should the trust have to pay the taxes, the utilities, the upkeep? What if the roof collapses? Who pays for that? So those are the things that they're fighting about, which means they're not fighting about the big ticket items. They're fighting about a lot of the little stuff. But as you can see, that's caused a lot of strife. We've read a lot about it. And even though we're here and next week Robin will have been dead a year, they're still fighting about it.
That's pretty amazing that, like you said, they're fighting over, considering how large the estate is.
It's estimated between 50 and 100 million.
And they're fighting over bicycles, among other
Yeah.
things.
Yeah.
But that's pretty amazing. I'd like to go back a little bit to talk about some of the healthcare documents we were talking about earlier. For example, you have the power of attorney, you have the living will, and especially with power of attorney, that's a situation that you really should probably have that drafted for your kids, not just when you become elderly and infirm, but something that when your children turn 18 years old, you have no authority to access any of their any healthcare information without a power of attorney.
I mentioned earlier that one of the important things in a will is who would be in charge of your kids if they were under the age of 18. Once they turn 18, you no longer have authority for them. So that son or daughter that you're super proud of that went off to Yale, okay, if heaven forbid they were in a car accident or in the hospital, you might find out that they're there, but the doctor's not going to talk to you anymore because they're over 18, they're their own person. That's why when kids go off to college, you should consider having them sign a power of attorney, a healthcare surrogate, and what's called a HIPAA release form so that you can deal with financial and medical issues in the event of a crisis.
Now, what is the difference between a living will and a power of attorney? Because a power of attorney allows the agent to act on behalf of the principal, that is the person that's signing the rights over, for a number of listed functions. However, a living will is something often that's associated when you go into a hospital.
Sure. So you described the power of attorney correctly. The only thing I would add is that it's effective immediately. Some states have what's called a springing power of attorney, which comes to life later. But if I give you my power of attorney now, it's effective now. So that's something to keep in mind. Now, a living will is a very simple document. It basically tells us if you are at end stage condition, and I am not a doctor, okay? I'll let our doctors out there define that more than myself. But basically, if you're brain dead, it's going to tell us whether or not you would want the plug pulled, whether or not you want food and hydration, and what other actions you do or do not want to have happen. It's basically, most of the time, it's stating it so that you wish to avoid any efforts that will keep your body alive. So more commonly known as, letting the machines keep me alive. So
now, is that distinct from, for example, a do not resuscitate order?
I'm glad you asked. This is a question we get a lot. A do not resuscitate order is a completely separate animal. Any client that can walk into my office, I don't want them to do a DNR. A DNR is basically do not resuscitate. That's what it stands for. That means, and it's a cardiac thing. It only deals with cardiac issues. So it says if you are having a cardiac issue, no medical personnel will touch you to try and make you better. It is really something that should be for end-of-life matters if you're going into hospice. Most young people have no need to do a do not resuscitate order. It would be overkill for most halfway healthy people to do. A living will, different. You're making a decision now on something that will affect you, maybe never, but at least you're making your wishes known. But the DNR, as I said, is something for whether or not you want them to make efforts to revive you if you're having a cardiac issue. And it's funny, it's one of the few forms that have a color. Unless you're in a hospital, it has to be on yellow paper, which is kind of a weird thing.
That's very strange. There are some ways that you can try to dispose of property without the use of a will or a trust, such as through a non-transfer or non-probate transfer device, such as a life insurance policy or a pay-on-death account or even just a joint bank account.
Those are very common. Most people have a retirement account that has a listed beneficiary, and I encourage you to check and see, if you haven't checked in a long time, who's the beneficiary. Most 401ks, life insurance annuities, the same thing. These are other ways of transferring assets at death without using documentation. There's advantages and disadvantages to those. One of the disadvantages of that is, you may not have updated it in a long time, or you may not want them to have all of the money immediately, or you may have put them in the document in such a way that they could access it during their lifetime.
So we have about a minute left. I just want to make sure that you have some time to give out your contact information to our listeners.
Thank you very much. If anybody would like to look for us, our main office is located in Weston, Florida. Our telephone number there is 954-747-1400. Our website, if you'd like to find out a little bit more of us, is Krause and Goldberg. That's KRAUSEANDGOLDBERG.com. And you can read about the attorneys at our firm. You can see some articles that we've written over the years, and you can also take a look at our blog, which covers a lot of the topics that we talked about today in a lot more detail.
And your practice areas include estate planning, probate.
My side of the office is estate planning, probate, exempt organizations, some IRS controversy work, and some asset protection work. And the Krause of Krause and Goldberg handles the real estate side of things. So closings, refinances, both purchase and sale, commercial and residential.
Well, that's the music playing us out. I'd like to give a very special thanks to my guest, Adam Goldberg. Please tune in next week, Tuesday night from 6 to 6:30, where my guest will be appellate attorney Elliot Kula. Thank you so much. This is Jeff Van Treese for Talk Legal, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on the preceding sponsor